And now, a special message from United States Senator John Hickenlooper.
Hi, everyone. John Hickenlooper here. Thanks for the opportunity to join you, at least virtually, on day 2 of CU Boulder's Right Here, Right Now Global Climate Summit. It's no secret that Colorado is on the front lines of the climate crisis, and our state faces unique challenges. Catastrophic fires, floods, droughts, they're all going to get worse if we don't act. But Colorado is on the front lines of the innovations that will help us tackle these problems head on. We also can't stop talking about the recently passed Inflation Reduction Act, which is the single greatest investment in fighting climate change by anyone ever. The IRA will drive clean energy prices down, create nearly 10 million jobs in the process, and put us within range of hitting President Biden's ambitious climate goals. While everyone has a part to play in combating climate change, the Inflation Reduction Act is a stellar example of the important role government has to play when it comes to creating an effective response to climate change. Thank you for having me, and enjoy the rest of the summit.
The University of Colorado Boulder, Colorado's flagship university, honors and recognizes the many contributions of Indigenous peoples in our state. CU Boulder acknowledges that it is located on the tribal territories and ancestral homelands of the Cheyenne, Arapaho, Ute, and many other Native American nations. Their forced removal from these territories has caused devastating and lasting impacts. While the University of Colorado Boulder can never undo or rectify the devastation wrought on Indigenous peoples, we commit to improving and enhancing engagement with Indigenous peoples and issues locally and globally. We will do this by recognizing and amplifying the voices of Indigenous CU Boulder students, staff, and faculty and their work. Educating, conducting research, supporting student success, and integrating Indigenous knowledge. Consulting, engaging, and working collaboratively with tribal nations to enhance our ability to provide access and culturally sensitive support and to recruit, retain, and graduate Native American students in a climate that is inclusive and respectful. Please welcome to the stage University of Colorado Distinguished Professor, Summit Steering Committee Chair, and former Dean of the University of Colorado Law School, James Anaya.
Good morning, everybody, and thank you for taking time to join us for this panel discussion on climate justice activism. This panel is part of the Right Here, Right Now Global Climate Summit that we're hosting here at the University of Colorado Boulder in cooperation with the United Nations Office of the High Commissioner for Human Rights. In addition to welcoming all of you who are joining us in person, I'd like to extend a warm welcome to all those joining us remotely online from various places around the country and internationally. As noted, I'm a member of the faculty of the University of Colorado Law School, and I served as the law school's 16th dean. Before introducing the panel, let me highlight just a few of the initiatives at the law school that are relevant to the topics being addressed at this summit. Colorado law has one of the foremost environmental law programs of any law school in the United States. In addition to our multiple curricular offerings on environmental law, our Getchus Wilkinson Center for Natural Resources, Energy, and Environmental Law engages in research and policy advocacy on a wide range of environmental issues, including issues related to climate change, such as dwindling water supplies in the Colorado River Basin and elsewhere. Our Environmental Law Clinic engages students in impactful environmental advocacy. Recently, the clinic has worked on a number of matters to enhance regulatory controls on the fossil fuels industry. Finally, we boast strong programming on human rights and Indigenous rights. Students from many countries have come to study in our advanced program on human rights and our well-known American Indian Law program, which incorporates work on environmental issues and human rights has been at the forefront of many of the issues confronting indigenous peoples in the world, and it has advanced legal protections for indigenous nations and peoples, including to confront challenges of climate change. And in cooperation with the Native American Rights Fund, the law school is now pioneering strategies to implement the United Nations Declaration on the Rights of Indigenous Peoples. With our strengths in human rights, indigenous rights, and environmental law, several University of Colorado Law faculty members have been deeply involved in organizing the summit. It's now my pleasure to introduce the panel. This panel is part of today's discussion at the summit of the human rights obligations of government and related responsibilities of business and other actors related to climate change. A key part of this discussion is how to advance accountability to live up to these obligations and responsibilities. Increasingly, we've already seen reflected at this summit how individuals and groups are taking action to hold governments and industry accountable for human rights and related impacts of climate change. Creative lawyering has already led to a number of important judgments assigning responsibility for these impacts. Other forms of activism are yielding results or showing promise. This panel will discuss lessons learned from the efforts taken through climate litigation in both international and domestic tribunals. It will also explore other strategies such as social and political activism, the use of art, and media campaigns. Moderating this morning's panel is Angelo C. Lowe. Angelo is an award-winning documentarian and social justice activist based in Johannesburg, South Africa. He uses his formal media training and training in journalism to bring awareness to the various issues, environmental and social and economic, that affect marginalized communities the most. As a journalist, he focuses on shifting perceptions of the climate crisis in order to be inclusive of all the people and communities that it affects. People of color often bear the brunt of society's ills, and Angelo's work goes a long way toward educating audiences of all backgrounds about this fact. He's produced a short film highlighting the economic exclusion of South African fishermen, using storytelling to create a space for awareness and education. Angelo's last documentary, which delves into the impact of big oil on South African township communities, is to be released this year. We're happy to have Angelo with us this morning to moderate a terrific panel. He will introduce the outstanding individuals who are joining the panel. Please join me in welcoming to the stage Angelo Lowe.
Thank you. That was a very kind and generous intro. I am honored to be here today, and it is a privilege to share the stage with some of the most influential change makers in the world. I never in my life imagined that I would be asked by the United Nations to moderate a discussion with such distinguished guests. But I also never imagined that there would become a need for us to have this type of discussion. Because when I was growing up, we understood that climate change was an issue. In fact, we called it global warming. But we had faith in our governments and decision makers that they would do the right thing and they would prevent things from getting to this point. And we were wrong. They were also wrong. And we are now at a point where we can no longer be bystanders, and we all have a role to play in ending the climate crisis. As a filmmaker, I imagined that one day I would make blockbusters and rom-coms and dramas that would entertain people, that would make them laugh, would make them cry. but instead I make movies that spread awareness, that share information, and that will hopefully affect change. I am a journalist by profession, and I'm an activist at heart. I became a storyteller so that I could change the way that people treated me, that people treated my community, and people like us. And as the climate crisis worsens, an understanding that the impact of the climate crisis will disproportionately affect communities like my own. It is the reason why I make documentaries and not those features that I used to dream of, for now at least. Because we are at a point where we can no longer be bystanders, where we all have a role to play in ending the climate crisis. And arguably, the people that are on this panel are some of the most important, or have some of the most important roles to play in addressing and ending the climate crisis, because these are the people that create and challenge laws that govern the way that the world works and the way that it operates. They are the ones that will set the limitations and boundaries that will reduce carbon emissions as needed. And so we will have a discussion on the role of litigation in achieving climate justice. And I want you to welcome with me and also give them a round of applause, because they deserve it for the work that they've done and the work that they still will do, the panelists today. So please help me welcome Tobita Chow, who is from the United States, who is the founding director of Justice is Global, which is a special project that aims to build a just and sustainable global economy, as well as defeat right-wing nationalism. He's a Chicago native who has well over a decade of community organizing and mobilization, and has a keen passion in making sure that people in the global south are not left behind in discussions around climate action. Everybody to beat down. Next up is Marika Faber, who is also based in the United States in New York City. She is a partner at Nota de Tel. I had to practice that a couple of times this morning. Marika's law firm, or at her law firm, she leads its Dutch dispute resolution and ESG practice in New York City. One of her most profound, I would say, cases is that she was involved on a pro bono basis on the Agenda Foundation's suit against the Netherlands government, which resulted in a victory, and courts ordered the Netherlands government to reduce its emissions by 25% by the year 2020. Faber also received the Resilience Award at the Dutch Legal Awards in 2020 for setting up a platform that enabled small businesses to access pro bono legal assistance during the COVID-19 pandemic. That is Marika Faber, everyone. Okay. Next up, and is with us in person, is Vivian Luke. Vivian Luke is also based in the United States and is the executive director at an organization called WORK. The mission of this organization is to enable or to assist families in Haiti out of poverty through good and dignified work. This organization works very closely with informal waste traders so that they could respect basic human rights as a standard for people in the sector. And so, ladies and gentlemen, Vivian Luke. Also, please help me welcome my fellow African, Legborsi Saro Payegbara, who is from Nigeria and has for many, many years stood on the front lines for the Ogoni people who were impacted by the oil spill in the Niger Delta. Legbosi has spent many years advocating for the community's rights and reparations, but has also sensitized the community to the importance of restoring the land and restoring the environment for the prosperity of the community. At the moment, he is the Executive Director of the Indigenous Center for Energy and Sustainable Development. Please welcome to the stage, Legbosi. And joining us online is another person who was involved in the monumental environmental victory and climate justice victory in the Netherlands, Tessa Khan, who is joining us from the United Kingdom. Tessa is the director and founder of Uplift, which is a United Kingdom-based nonprofit organization that is calling for the just transition in the UK away from fossil fuels. She is an international climate change and human rights lawyer, campaigner, and strategist. She was named in 2019 by Time magazine as one of the 15 leading women to fight against climate change. So she will join us virtually. Let's give her a round of applause. Awesome. We have a lot to speak about in a very short space of time, so I'm going to jump straight into it. But just to remind panelists and to welcome panelists to share with us their pronouns in opening remarks. I'll go first. I go by he, him. And also to invite panelists who have something to contribute to questions that are for other panelists, just to raise your hand and let me know, and then we can make that contribution after a panelist has spoken, or if there's a follow-up question, same process. Okay. I want to start with the Netherlands victory. I want to discuss that because that is a monumental success story for us, and because we have two panelists who were involved in the case, I wanted to speak about, sort of give the audience a reality check and what it takes to create that kind of success, what it takes in terms of resourcing as an individual, but as well as organization. And I direct this question at Marika as well as Tessa, but I think let's start with you, Marika. What was that experience like?
Thank you. First of all, I'm honored to be here, and thank you for the kind invitation. As you pronounced correctly, Nelta de Thiel, we were involved in the Supreme Court proceedings. So we got on board in the appeals phase to prepare for Supreme Court, and we therefore cannot claim any credit for the 2015 judgment, which really was the Urgenda Foundation alongside legal professionals in the Netherlands that worked towards that victory. And I think I can say, and I think Tessa would agree with me, that it takes a village to get a case like this off the ground in terms of legal preparation, in terms of campaign preparation, and also in terms of vision, because it takes vision and persistence to move all the way through the courts. And we got on board in the appeals phase and then took it to the Supreme Court. And that too was an international effort where international experts were invited to share their experiences, all to build this case and make it as resistant as possible to really go into the books as a Supreme Court victory rather than only a district court victory, which can be very impactful, as we will see and we'll discuss in the Shell case. But ultimately, having a Supreme Court get to a judgment like this, that is sort of the hallmark, and that is why I think it was also so impactful on an international basis. But I'm also happy to, looking forward to what Tessa has to say about this.
Tessa, greetings.
Thanks so much, Angelo, and thank you so much for the invitation to join you all remotely. I'm really delighted to be part of this discussion, and my pronouns are she, her. So I completely agree with everything that Marika has said. I think there are three things that I think are also worth highlighting in terms of what it took to get the case off the ground in the Netherlands and ensure that it had the kind of impact that it ultimately did, because I think as many public interest and human rights lawyers know, even if you're successful in court, that may not translate into real political and social change unless you've thought quite strategically about how to ensure that there's real accountability for the decision of a court. So, but to go back to, I think, probably what was the most important quality in the leading Dutch lawyers who were part of the initial effort to devise the case and file the case, is they just had an appetite for risk that is really exceptional. I mean, I think generally within the legal profession, we are pretty risk averse. And I often heard from my Dutch colleagues that 99% of lawyers that they spoke to in the Netherlands told them that it was impossible and that it wasn't worth doing. But in the face of that, they persisted with what was, you know, ultimately in so many ways a really groundbreaking case, not just because of the impact that it had, but also because of the kinds of arguments and legal norms they developed and relied on. The second thing I'll say is that it took an enormous amount of preparation in terms of getting to grips with the science in a really granular way, in a way that I think a lot of lawyers aren't accustomed to, because I think they took the view, the Dutch legal team really took the view that they had to be able to explain the science in language that a judge would understand without relying on technical experts. And so that was a huge undertaking that I think they executed really brilliantly. And then finally, as to that strategic thinking that I mentioned that's necessary if we're going to make sure that these cases ultimately lead to any kind of transformation in the real world, is that Agenda thought from day one about how to make this a case that wasn't just an environmental NGO taking on the Dutch government. It was seen to be an effort and an argument that was representative of what a broad cross-section of Dutch society wanted. There were 900 co-plaintiffs. There was a campaign and a communication strategy that supported the case to make sure that there was real engagement with the media and with Dutch parliamentarians, so that if they were successful, there was sufficient pressure coming from multiple quarters, not just from the judiciary, to ensure that the government followed through on what would be a transformative judgment if it was successful. So, you know, that's the kind of thinking that went into it from day one.
To understand what some of the opportunities were in Dutch law that enabled a victory like this. Like, what is it that was so specific about that country that made it possible for, or the country's laws that made it possible for this victory to have happened?
Yeah, a few thoughts on that. The district court, so the 2015 judgment followed a tort-based ruling, and I think that the concept of tort in itself is a concept that we see in many other jurisdictions, civil law, common law. So that in itself, it is an open textured norm that the judge and the court can use as they please to a certain extent. So that I would not see as a singular opportunity in Dutch law. However, what happened in the appeals phase, I think from a human rights perspective, was particularly interesting, because the Court of Appeal revisited the standing requirements of Urgenda under the convention, and where the district court had said, well, Urgenda, you do not qualify as a victim under the Human Rights Convention, and therefore you cannot directly invoke the right to life, Article 2, and the right to family life, Article 8. They were only indirectly weighed by the district court. The appellate court said, well, you have to apply Dutch standing requirements, and those are much broader. So through that avenue, the court opened the door to the European Convention of Human Rights and invited in the direct application of human rights principles. And I think that was a game changer in this judgment that was a monumental decision in a way, and that allowed the direct application, also invited in the enormous body of precedents under the European Convention. So I'd say that was an opportunity, and maybe just a third thought is that also the party debate, I think, contributed to this decision as it went, because the Dutch state never contested climate change in itself or the grave consequences thereof. And that really facilitated the court in accepting that. And then, of course, there was a huge discussion on what the court's role should be versus the government and causality discussions, etc. But the gravity of the problem itself was sort of a consensus among the parties. And that, I think, allowed the judge to be courageous, because it was a courageous court. They could have gone different, they could have dismissed the claim easily. And it was also carried by Dutch society, also through the campaign efforts, I think, that Tessa mentioned.
Tessa, you mentioned that there are some challenges in enforcement and sort of in action. It's one thing to have the victory, but what difference has it made, aside from set precedents for other sort of victories or court challenges?
Yeah, that's a great question. I mean, a 25% reduction in Dutch emissions by 2020 really did require the Dutch government to take a range of measures that it otherwise wasn't going to take, if you look at the trajectory of the Netherlands emissions in the absence of the judgment. So essentially, the government ended up reducing the capacity significantly of a number of the Netherlands coal-fired power stations to reduce emissions. It spent billions of euro on a host of other carbon-cutting measures, and in order to ultimately produce the emissions reductions that were required by the court. I think, though, one thing that's a bit more difficult to quantify, but in my view is just as significant, is the way that the case really raised the profile of this notion that the Dutch government was failing to do what was needed to protect the human rights of Dutch citizens in terms of its action on climate change. And that really opened up a conversation around the Dutch government's responsibility that really enabled a number of other quite important developments that were not a direct result of the judgment in that case, but were very much connected to the sort of discourse that developed around it in the media and within Parliament. So the Dutch government ultimately ended up passing a Climate Change Act with much more ambitious emissions reduction targets for 2030, for example, and it just became a part of the public debate in a way that it hadn't before. So I think, you know, in order to really assess the impact that these cases have, not to mention, of course, as you say, the legal precedent and the inspiration that it created for so many other activists and lawyers and campaigners around the world. But, you know, there are often a number of ripple effects associated with cases when they are litigated strategically.
Marika, you had a follow-up.
Maybe just a quick follow-up, and I completely agree with the impact that it had in Dutch society and on Dutch government. However, from the Urgenda perspective and from our perspective, the reduction did not go as fast as needed. So when in 2021 the preliminary emission data became available, it actually looked like the Dutch government had not done enough to get to the 25%, and they were short 0.5%. And we started preparing follow-up proceedings, actually, to enforce the judgment. And that is a whole legal issue that I can talk about much longer, but it's exceptionally difficult to enforce a judgment or this reduction order against a state. You have to think about what incentive can you provide a state. Should it be a large penalty? Should it be, what can it be? The Urgenda Foundation doesn't want billions of dollars if the state does not comply. That's money that should be spent by the Dutch government. So there are many logistical and legal hurdles in the enforcement process, but it does go to show how vulnerable a judgment like this is at the same time. It has a lot of impact, but it's also vulnerable, because how do you hold states accountable afterwards? We ended up not bringing this suit because the definitive data showed that they just made it because of Corona, because of a very mild winter. So there was a bit of luck involved, which, you know, well, so that is just my additional note to that it's just really challenging to actually hold the government then accountable.
There was also a lot of opportunity that came from this victory. And I wanted to, you mentioned earlier about Shell and the Shell case. I don't know if you want to reflect on how there may have been there may have been precedent drawn from the Netherlands victory or the victory against the Netherlands government in that case at all.
You mean the Shell case against companies? Yeah. So I absolutely. I think that the Urgenda judgment and the reasoning behind it, the tort-based reasoning that I referred to earlier, was basically copy-pasted to the suit brought against Shell by another NGO, Milieudefensie, and who was also ultimately successful. Here, the court also used the tort norm and gave it substance by also human rights principles, for example, the UNGPs, the OECD guidelines, and came following a similar pattern of reasoning to the conclusion that Shell will have to reduce 45% by 2030, which is really had a major impact on Dutch society, on companies in Dutch society. I think it can be said international impact. I received a lot of phone calls from also lawyers internationally, like what should we tell our clients? What do we have to do? So I think this is only one example where the Urgenda judgment really had an amazing follow-on impact.
I also kind of want to speak about opportunities because that was within the jurisdiction of Netherlands law, but what are the opportunities or the legal opportunities that exist for other countries in the world because of this judgment? Tessa, perhaps you can speak to that?
Yeah, certainly. I mean, as you can probably tell, I'm not a Dutch lawyer. And, you know, what I found so fascinating about Urgenda's case when I got involved was the fact that they were relying on human rights that are protected by the European Convention on Human Rights. So they are, you know, rights that are common to all of the countries that are signatory to that convention. But the vast majority of the world's countries also have constitutional or legislative protections for human rights. And so the reasoning that was used in the Urgenda case was in many ways at least worth considering how to replicate in other countries that also have human rights protections in order to compel governments to take more action on climate change. And as predicted and you know, due in no small part to efforts by my colleagues in Urgenda and others that we worked with to really try to help other lawyers in other countries understand how to apply those human rights norms and bring the science together the way that was managed in the Netherlands. Basically, the sort of human rights-based reasoning that was used in the Urgenda case has now been used in, I would say, countless other countries and cases. I mean, you know, even in the couple of years after the district court decision, there were already cases that were being developed in Belgium, France, Ireland, Germany, Colombia, South Korea, Australia, and the number of those cases has just continued to escalate, really modeled on the kinds of human rights-based arguments, albeit adapted for local jurisdictions, but, you know, broadly consistent with the approach that was taken. And as Marika said, you know, it was also the inspiration for the reasoning that was used in the Shell case. So I think it's, you know, it's a case that's had a really transformative effect on the way that people litigate climate change against national governments. And I still don't think we've really hit the limit of what can be learned from the 3 decisions that were issued in that case and how they can inform legal strategy in other countries.
And I asked this question because in the case of Shell, when the Dutch courts ruled against them, they seem to have simply uprooted and moved their headquarters to the UK, to a more favorable country. And so it is important to understand what activists have at their disposal in terms of litigation and the opportunities to challenge governments, because companies will negate responsibility because they're able to do this. But I do want to reflect on Shell, and Saro, you've assisted many legal battles against Shell over the years on behalf of the Ogoni people. And I'd like for you to reflect a little bit on some of the legal work that you've, or some of the cases that you've assisted communities with.
Well, first of all, I have to thank the organizers of this forum. I think it is coming at the right time. And I also want to salute the indigenous owners of this territory. I am from an indigenous community in Nigeria, the Ogoni people. Something is also very striking. The fourth IPCC report actually stated that 4% of GEG emission globally just from Africa. But the striking thing about that assertion is that South Africa and Nigeria were noted as those that contributed 90% of the 4%. But what I will tell you here is that 90%, within that 90% coming from Nigeria and South Africa, of course, more than 50% comes from the Ogoni community, where Shell have been operating for decades. And that long years of operation in Ogoni and in the entire Niger Delta led to some of the crises and the challenges that we've seen around that environment. I think there was something I saw yesterday in one of the courts when we entered this building, which it said the difference between the future and the past is what we are doing now. So what we are doing now is what matters. What we are doing now is what will take us to the next level. It is already accepted that Mother Nature is in crisis. As I speak here, I know that in my community around the Niger Delta, thousands have been displaced because of flooding. As I speak here, I know that the harvest next year is going to be terrible. They're going to have food insecurity because most of our people depend on farming and the fishing, and because of the floods all around, definitely the harvest for next year is going to be poor, and because of the dislocation, people are going to face serious food scarcity. So climate change is real. Anyone denying it just denying it at their own detriment. As I said, I happen to come from Ogoni where Shell was operating for several years with gas flares, and one of the things we saw, particularly around that period, was particularly where the gas flaring was going on, was that there was so much increase in temperature around those environments. And people started noticing that even the plants, when planted, were not growing well, all manner of diseases were coming in. But the most striking is the fact that within this period, and that is also what we're going to notice around the issue of food insecurity, is the fact that Ogoni depends more on what you may call rain-fed agriculture. And when the time for the season to set in for farming is supposed to set in and it's not coming, definitely affects when they need to go to farm to plant. And that becomes a big challenge. My grandfather never used anything called clock or watch. But from traditional knowledge that he has, he knows when it is 1, 2, 3, 4, by just looking at the sun and the shadow. And that's what we knew. But all that is being eroded because of these whole changes. Now, after seeing all these things, of course, the Ogoni community organized themselves under the movement for the soil Ogoni people. We started challenging Shell and all the operations in Nigeria. Of course, all of us know that Nigeria is a third world country with a strong alliance between the oil company and the government, particularly when the government depends on a monoproduct economy. So the Ogoni uprising was actually a big challenge, not just to Shell, but to the government and the structure and the political elites in Nigeria. So that repression was also visited with serious repression, of course. Most of you here know about the hanging of Ken Saro-Wiwa in 1995 and thereafter. But looking back, what this whole thing has done, it has, and that is why I said I would like to say here that we have power in us. As a people, as a community, those who are committed to social justice, we have a power in us. And that power is what we need to use in a time like this, because we use it in Ogoni. There was a time, at a point in time, everybody dreaded Shell in Nigeria and even outside Nigeria. The Ogoni uprising was the first confrontation with Shell. And after that, of course, that empowered many communities, not just in Ogoni, but also we're going to start looking at taking Shell head on. And that for us is the beauty of what we've done in Ogoni. The fact that its impact has led to situation where other communities are raising up and the challenging not just Shell, but other oil companies across the Delta. And of course, as I said, we started different processes. One, of course, we have to massively, and that is, well, before you go into litigation, the community must be fully aware, must also understand what they're getting involved with. And that was the beauty of what we did in Ogoni, because we did both horizontal and vertical mobilization of the Ogoni community across board. And that led to the where most of what we may call 10 affiliates. You have groups responsible for the youth, you have groups responsible for the students, the women folks, so everybody was mobilized across the line. And because of that mobilization, that helped everybody to know where we're going, and that brings the whole question of art and music. Music relating to some of those core issues we're introducing the struggle, different art we're introducing the struggle, which resonate with the sort of thing, traditional ways of life of the local community, and that helped them to understand. And that was, at that point, we started building the cases. Of course, most of the communities, like you have the Border community case that was settled in London, which of course the court awarded £55 million as compensation with a clear clean-up plan for the community, which of course was a moral victory for the community. One other striking case is the one that was done at the national level, which involved gas flare. One of the community took Shell to court relating to issue of gas flaring. The gas flaring has actually affected their right to life and also their food sources. And it was a victory because the church for the first time, the court for the first time ruled in favor of the community that actually Shell operations are affected because of the gas flare that was going on, affected their lives, affected their livelihood. And that was the national level. Of course, currently, we also have a case in London with the Chibapabe. Of course, that is one of the communities haven't done this whole exercise, the struggle. We got to a point, and the beauty about the Ogoni thing has been that sometimes I always ask myself whether the Universal Declaration of Human Rights was created for the Ogoni people or passed for the Ogoni people, because we try to amplify every human rights process that we see. And that helped us, particularly the special procedure mechanism that we used at some point, led to the special rapporteur then to recommend that there should be an assessment of the Ogoni environment. And that we committed UNEP into doing the assessment for 3 years, and they came out with a report, which identified for the first time that the water system of Ogoni were polluted to the point that benzene were 900 times higher than the World Health Standard found in water sources, which is the basis upon which the Gali community, led by Chibapabe, is now in court in London. Of course, people are now falling back to what you may call the parent company liability, and that was the argument going on in London at the moment. But it also shows the failure of the system at the national level. And that brings the question you asked before. People are already fed up because of the weak legal systems to now go abroad to seek for justice. And of course, in the Ogoni case, it has helped because in the Netherlands, there has been some success. Of course, the London case, there has been some success. And the current case in London, too, so far, we're hopeful that something good will come out of it.
And that's something that I kind of want to expand on a little bit, is how Shell is negating from its legal responsibility, because, I'm from South Africa, and at the moment, Shell is constantly taking organizations and grassroots organizations to court to overturn a court's decision that they are not allowed to have seismic blasting along our coastline. And so there's a legal victory, and they keep challenging these organizations that have very little resources. And I wanted to kind of expand on some of the ways that Shell deflected responsibility in the case of the Ogoni people.
Well, part of those deflections, if you look at the history of oil operation in Nigeria, from 1936, when they started off, where they first discovered the first oil, well, in 1956. That was the time that the knowledge of our people, particularly in the country, was completely poor when it comes to legislation relating to the oil industry. So practically, it was Shell, the oil sector people that define the legal regimes that we see in Nigeria, particularly when it comes to oil. And that was part of the reason why it was easy for them to be manipulating the systems. And because of that weak legal system, it was also difficult for several years to take on share within the system. And that has been part of the thing that we saw, that we've seen across the board. Now, but people, I mean, what has happened with the Ogoni struggle? We have seen situations where judges, I mean, we are now seeing rise of judicial activism that is making judges to interpret some of these things within the context of some of our international commitments. I mean, like the case on the gas flaring, the judge actually relied on the African Charter and the issue of right to life and the fact that Nigeria has signed a domesticated African Charter, so which was not what is in the current law books. I mean, so they have to be imaginative in looking at the African Charter and the fact that Nigeria domesticated it. If not that, the weak legal system enables them to play around the system. Secondly, I mean, there was another strategy that was long used. I mean, what they do when in cases of environmental abuses, where, particularly in case of oil spill, you know, you are fighting with local community that don't have resources. So these guys can put it in court and keep it in court for the next 30 years. But with time, all the people that were involved had died, and then the matter just died like that. So we also noticed that within the period. And then the third thing, which relates to the question of corporate capture, have been the fact that over the years, we have key government officials that had interest within the oil industry. I mean, there is a case of one permanent secretary, Philip Asiodu, who ended up becoming a board member of Chevron on retirement. So we later discovered he was a minister of petroleum. So you can now see the alliance between those in government and those in the oil industry. And when they're out of office, they're compensated with some of those things. So I think those are some of the ways they manipulated the system to, I mean, run away from the legal responsibility. You know, this thing is evolving. Initially, it was, they would do their work, and when you complain, they say, oh, they're paying tax to the government. So it is government responsibility to do ABC. And of course, after the death of Ken Saro, we see the emergence of corporate, the whole question about corporate social responsibility, which of course fall within the voluntary thing that we are saying is not working in the system at the moment.
You know, with this sort of trickiness around holding corporations accountable, I know that in our planning discussions, you had brought up loss and damage as something that is key and essential, because otherwise we're chasing around corporations. I don't know if you want to expand on that, and Tabitha, if you would also like to add to that discussion also.
Yeah. I mean, okay, at the same point, we've been following the debate around corporate, climate change, as I said. I mean, most of that I rose to become the president before I started doing what I'm doing, the Indigenous Center. We've been at the forefront of the whole claim about gas flaring, oil extraction, and climate change. So we've been involved, and of course, at the last COP, we were also there. As part of the negotiators, we also engaged some of the states on the need for a funding mechanism for loss and damage. Of course, at some point, it is celebratory at this point, that at least a funding mechanism is established. How it's going to be operated, how it's going to be done is what we don't know. For those who work for indigenous communities, I think part of what we raised at that the last COP was the whole question of direct access to funding. So if you are creating a mechanism, how will the indigenous people also have direct access to those funding? Because we are at the front line of climate change. We are also suffering the highest, but at the same time, we also have indigenous knowledge across millennia, across centuries, that can also be being deployed by different communities to address climate change. So at some point, they also need some resources. So while we welcome the whole thing about loss and damage and the funding mechanism, at the moment, of course, nobody knows how the structure is going to be, how the fund is going to be. But I think it was a strong desire that for indigenous people, I have had the opportunity of serving on the Climate Investment Fund as indigenous observer. I was also serving on the Global Environment Facility. And we know some of the challenges we have trying to, because those are all funding mechanisms from UNFCCC, including that adaptation fund. In fact, the adaptation fund is so bad that at the moment we don't have that sort of access. So we are doing a new mechanism now, which is, of course, as I said, welcome. The next stage for us is how to see that indigenous people have direct access to that funding. There have been some debate about the fact that, while some celebrated Egypt, some also have we also have some regret, particularly when it comes to the fact that the old lobbying from the fossil fuel industry and the fact that COP27 ended without any strong resolution on the whole question of fossil fuel extraction, also disappointment. But on the other side, on the loss and damage, it was also a success. But if we are getting funding to address a question of loss and damage, and at the same time we're not reining in fossil fuel extraction, it becomes counterproductive. So that's the challenge.
Rita?
Yeah, our role at Justice is Global is to build a grassroots power and political support for the US to do better on issues of global justice and support better policies. I remember when I heard the news that this loss and damage facility had been successfully, that the decision had been made, and that the US government in particular had agreed to that. This is all too rare an experience for organizers. I was like shocked, but in like a very pleasant way. Good news is, you wanna really cherish those moments. In the weeks leading up to the COP, the US climate lead, John Kerry, had very publicly and in no uncertain terms dismissed the very idea of US support for a loss and damage facility, dismissed it as basically a fantasy. And hearing that, I sort of, I didn't lose hope in the loss and damage effort, but I thought, oh, this is gonna take some time. Like, this isn't gonna happen this year. Like, this is gonna be like a long-term fight. But then it did happen. And I think it's important as someone who's interested in movement building around issues of global justice, including around climate, to look at what happened there. And a couple of the dynamics that I would name are, that I think can also give us hope for the future. One is the level of global South unity from the G77 plus China bloc that was pushing for loss and damage. In the past, in international climate negotiations, there has been a strategy from global North countries that has all too often been successful to break up unity among global South countries, demanding, making demands of them. And on this occasion, those efforts failed. And the global South bloc maintained its unity around this demand for the creation of a loss and damage facility. My understanding is the small island states played a central role in holding that bloc together. And then what happened is, instead of the global South countries getting broken up, it was the global North countries and their unified opposition to loss and damage that started to waver. And one by one, the global North countries' governments started to agree until it got to the point where the US government found itself almost entirely isolated in opposition. And it was like looking really bad, and that created an enormous amount of pressure on the United States. In addition to that, there was also pressure from within the United States, and I think it's important to understand, for me as a campaigner, like how these two things can work together. Pressure coming from the outside on the US government, particularly from the global South, combined with pressure coming from within the inside. So we were part of a coalition of groups that worked to create increasing political pressure on the White House to agree to the creation of a loss and damage facility. One form that this pressure took was a sign-on letter from members of Congress, led by some progressive members of the House of Representatives. And I want to name what I see as like two important features of that effort that I think are consistently important in our work within the United States to create more political support for issues of global justice and international climate policy. One is the racial justice angle, presenting these demands as racial justice issues, which have become very politically powerful within the US context, particularly within the Democratic Party. If you can make it very clear that denying a demand means that you're on the wrong side of a racial justice issue, that's something that, particularly on the Democratic Party side of the political spectrum, can be very powerful. The other angle is the role of Global South diasporas within the United States. The US has been the imperial power in the world. One of the flip sides of that is so much of the world is here, and in particular, people who come and have recent immigration histories from Global South countries where people are suffering the brunt of the systems of injustice that the US government often plays a key role in upholding. They are here in the United States, and they're in positions of power and influence, including in the House, in the U.S. Congress. And so a key role was played in this effort within Congress to put pressure on the White House by members of Congress who come from Global South diasporas. So, for example, Representative Ilhan Omar played a leading role in this letter, and also had support from grassroots organizing within her district, and that grassroots support from within her district helped empower her to make the boldest possible demands of the White House. And so this combination of pressure from within the US, the role of Global South diasporas, and this having a racial justice framing combined with unified demands from the Global South, that combination, on this occasion, there have been other occasions as well, is what, in my eyes, played this critical role in flipping the position of the US government, where there's a lot of entrenched interests and also ideological commitments that more often than not lead the US to become a leading opponent to demands of global justice. But that opposition can be overcome, and I think those are some of the key ingredients.
I think it's really interesting that you mention racializing or racial justice, because it is communities of color, no matter where you are in the world, that experience disproportionate impacts of climate change. It's also these communities that are usually situated right in the middle of these industrial areas that cause ill health, that cause spirals of poverty. In fact, the documentary that I just made covers that exact thing in South Africa. And I kind of want to sort of reflect on that a little bit in terms of Global South and this tendency to kind of shift south, if you put it that way, whenever a company is blocked. So we see it with the oil companies now in oil colonialism, as some of my activist colleagues call it, but also we've experienced waste colonialism, where Africa is now where everybody tries to ship their plastic waste to. And Vivian, I wanted to speak to you a little bit about that, because you work predominantly with waste pickers. And I firstly wanted to ask about the impact of the waste trade agreements on informal waste pickers and how they leave that sector of people vulnerable.
Mm-hmm. Yes, thank you. Thanks for having me here today, and thanks to everybody who's tuning in virtually and also here in the audience today. It's good to be here. So our organization works with informal waste collectors globally. We work to implement direct programming that improves the livelihoods and the worker well-being in the work that they do. On the other side of that work is the transformation of entire supply chains, so that what we recognize in the very beginning of working with them is that their livelihoods and their worker well-being will not shift and will not change until they get recognition for the work that they do, until they're understood as a key player in that entire supply chain. So we work directly with recycling facilities and brands and manufacturers who utilize the recycled material to ensure that they understand their responsibility in addressing the issues that are taking place in the informal waste supply chains. So when it comes to the global waste trade, I think a lot of the waste collection that are taking place with informal waste economies have been taking place for decades. And even though there's been a lot of shift in the global waste trade recently, there is still majority of that waste is being collected, that are being collected by informal waste collectors are taking place in the global south, in places where there's a lack of infrastructure, where there is a lot of high level of immigrants and migrants in those communities who are looking for an income source to put food on the table, to support their whole families. Where it impacts them the most are those who are working directly in open landfills. In the places that we've worked in Haiti, Honduras, Taiwan, Ghana, those are areas where while the waste trade is I think mostly impacting places like Southeast Asia today. The informal waste collectors' work is monumental in the times that we are in today, because they need to be, one, recognized for the great work that they do, but two, also be connected into that entire supply chain as well. So, I think the issues with the waste trade is that it does prominently sit on top of the list for a lot of brands who are buying that material, because it is about that supply and demand. But for the waste collectors themselves, there is so much material out there to collect that there needs to be increased resources to support the work that they do on a day-to-day basis. And even if, and at this moment, it needs to come from all sides. It needs to come from policies and redistribution of waste and responsibility of waste for countries who generate them and brands who generate them. But it also needs to come from programming to support them. It needs to come from alternative work that they can tap into instead of doing waste. It needs to come from governments to build infrastructure of those economies so that they can all benefit from it, but also not be denied any access to the work that they do.
So in a past life, I was the Pan-African anti-plastics campaigner at Greenpeace. And one of our demands is the end of plastic waste, the end of single-use plastic, because we've noticed that in recent years, there's been a spike in the demand or the supply of plastic to compensate for a reduction in the demand for oil. And so if that's the end goal, if we're meant to tackle the climate crisis and we need to reduce the demand for fossil fuels and reduce the demand for plastic as well, what is it about formalizing these workers' rights that's going to protect them in the instance that there is a drastic reduction in plastic production?
Well, one, I think it's going to take a while for that drastic reduction to take place. So two, in the meantime, we have to acknowledge that they exist and the work that they do. We have to put resources in place for them to do their jobs and to do it in a way that is safe for them to do so. We have to put infrastructure in place. We have to also incorporate their voices in how we shift the system and transform the system as well. Not every informal waste collector, actually, majority of the informal waste collectors that we speak with don't want to be formalized. They actually, they appreciate the flexibility in the work that they do. They have figured out a way to collect waste in a manner that works for them, that benefits them. We've spoken with many waste collectors who have been formalized, who tells us that they're making far less money now that the work is formalized, and it has really impacted their lives, right? So I think as we are working to figure out how to shift the system, how do we eliminate single-use plastic, which any informal waste collector that we've spoken with would advocate for that as well. Because it's not about having more waste in the waste stream for them to collect. It's about how to do this work in a better way, in a structured way for them as well. And so one, and it's different everywhere because of the infrastructure is different everywhere. So how do we, when we do this work, how do we incorporate their voices? How do we ensure that they have a seat at the table and they're part of creating this new transformation in how we collect waste and how we manage waste and how we recycle it, all the way to, if you ask them, how should a plastic bottle be redesigned so that it can be better utilized as a recycle asset, they will have answers for you. And so how do you incorporate their voices all the way to the top of that supply chain as well in product design and development, and in enabling their expertise to be utilized in the right ways.
I'm very curious, and this is a question I will open up to the rest of the panel also, but I mean, you work in sort of trying to advocate for laws at a government level, but you also work with companies on advising them on how to bring that human rights element into what they do. And I guess we can look at it from the lens of suing and challenging governments versus corporations, but also what do you think is more fruitful in trying to create this change, going after governments or going after companies?
Both. I know it's not the answer you're looking for, but I think we need to do both. And I think what's powerful about everybody sitting here today is that we all attack a different piece of that. And you see that manifest in how our informal waste collector communities get to work today, can benefit from that work today, right? So when it comes to working with corporations, when they procure plastic materials, they're only asking for volume, they're asking for quality of the material, and they're asking for whether or not a vendor can deliver on time. They're not asking anything about who's collecting that material, how many hands is it changes until the material gets to them, and what are the conditions in that work, right? So one of the efforts that we do in consulting with brands is to build human rights framework into their procurement frameworks. How can we do that aligns with your human rights declarations, for example, and ensuring that there's one starts with traceability, starts with understanding who's actually even collecting, recognizing that they're there, and then recognizing your responsibilities towards that. But where government plays a key role into that kind of work is in ensuring that policies like extended producer responsibility schemes exist and are being enforced. But right now there's still so much work to be done with EPR schemes around the world, where again it's really focused on volume and quality level of that material, but it's not focused on human rights just yet. So that's the push that we are making, and that's the push I think that governments and litigation can play a big role in.
Tessa, we haven't heard from you in a while. Do you have any thoughts on this question around who would be better to not hold account, but what would lead to that faster victory or that faster change, challenging governments or challenging companies?
Thanks, Angelo, and I'm sorry to disappoint you and kind of echo, I think, Vivian's remarks, but I really think at this point we've got to go after both, and that there's real value in holding both governments and corporations responsible, especially if we're talking about the need to drastically reduce the use of fossil fuels, which of course drive the vast majority of greenhouse gas emissions, the burning of oil, gas and coal. And I say that for two reasons. The first is that, of course, governments are the only actors that have the sort of systemic regulatory and investment powers that we need to transition our economies at the speed and scale that the IPCC and other expert bodies have made very clear we need to, if we are going to stay within critical limits of climate change, like the 1.5 degree threshold. I mean, only governments have the set of powers that can shift entire sectors and entire industries and invest in the alternatives, namely in renewable energy sources, to ensure that we're on that pathway. On the other hand, companies are, of course, and I'm talking now about the fossil fuel industry, but they are profiting from continuing to entrench the status quo and the very dangerous economic model that we have now, which is heavily reliant on burning fossil fuels. And of course, not only are they profiting, and I would say at the moment, especially in Europe as a result of Russia's invasion of Ukraine, they are profiteering from exceptionally high fossil fuel prices driven by that war. But though that industry has also actively funded the denial and the obfuscation of climate science. It actively lobbies against progressive climate policy, continues to do so, and is engaged in all kinds of, very dangerous discourses of delay around climate action and advancing what I think a lot of people refer to as false solutions that simply distract us from the fact that there is no way to address the climate crisis unless we radically reduce the use and combustion of fossil fuels. That industry, of course, as we've heard from Saro and others, is very powerful in influencing the decisions that governments make. So while it is ultimately only in the power of governments to license the use of sovereign extract resources like oil, gas and coal and the extraction of those resources. So it is up to governments to decide to license or not license that activity. The fossil fuel industry, particularly oil and gas companies, are incredibly politically and economically powerful and influential in ways that we've absolutely got to curb if we expect governments to move at the pace that they have to. So I think, that's why I'm in favour of making sure that we are litigating and campaigning against both governments and the fossil fuel industry, the two sets of actors that ultimately bear responsibility for this crisis.
I think that's fair and makes a lot of sense. The idea of challenging governments to change laws and then challenging companies to abide by those laws. Marika, you had something that you wanted to say or contribute to this, I think, or unless you just twitched, but it looked like you were about to say something.
I think it's such a fundamental question, and I absolutely agree with and I echo what has been said before, that it's a collective effort where we need both the private and the public sector. And the tool of litigation I think there is a balance to be struck. What we saw in the Urgenda case, what we're also seeing in the litigation environment in the Netherlands is that the courts are about at their limit. Now it's also up to the government to really get that legislation in order, to really provide guidance to also the private sector, to really provide that stable investment environment where the transition is enabled. And there we see that the government is struggling, but the question is, how far can the courts push the government? Because ultimately there is the separation of powers. And there is this discretion where, well, the courts arguably will not go. However, and this is a very new development actually, this was a case that, a judgment on Wednesday, where the courts in the Netherlands denied the claims of RWE, which is a very big energy company, to get any compensation for the fact that they had to close in 2030. And this was one of the very powerful instruments that the Dutch government used to get down or to reduce those emissions. That is the Fossil Fuel Phase-Out Act. And you see that there the court is sort of providing the government with leeway to actually take those very painful decisions. But obviously, and that is, I think that what you refer to, the sort of whack-a-mole, dynamic that you create, where you also need this stable investment environment for the transition to occur. So that is a very delicate balance. And then I have another thought on the private sector. Judgments like the Shell judgments are incredibly impactful. And I'm in private practice, so I did the Urgenda case, but I mostly advise companies and the financial sector how to go about this transition and how to interpret the vast amount of European legislation that is coming up and is being developed. And what is very alarming to me is that I also see that the whole accountability culture that, and I'll speak for the Netherlands, exists also has a bad effect on their level of ambition. Because what if they don't make it in 2030? And what if the reduction targets are too ambitious? They are afraid of getting sued left and right or getting bad publicity left and right. And that is ultimately also not the direction that we want to go. We want to foster that ambition. And we have to also, I think, acknowledge that we are in very uncertain times and that the transition reality is an uncertain one. So to the companies, and that this is where my nuanced view comes in. I completely agree with Tessa that the fossil fuel industry is you should separate that maybe a little bit, but to those companies that really try to go through that transition and are currently struggling to go through that, there's also that little bit of space and a learning ability that is also important to acknowledge. And accountability remains very important, but I do question whether litigating against every single company is going to provide the solution. I think it's more of a holistic effort where the government has a very strong role to play, and where we as activists, semi-activists, people that are very involved with the transition should also always ask the question to themselves, is this going to help? Is this going to contribute to getting where we want to be? And I think that is a question that we should keep asking ourselves.
Vivian, you have
Yeah, and I think to your point, government and the role of law has a lot of different applications to it, right? So litigation is one, but enabling policies also work really well in a lot of cases. So we hear from a lot of brands that they need to make adjustments internally because of pending legislations that are coming down, and wondering how it's going to be enforced, et cetera, and that's great. The other side of the coin for them is where's the consumer demand going to come from? And how is consumer going to react to our changes? If you're using higher quality material, there's going to be a change in pricing. If you're using, if you can keep at pace with the level of single-use plastic that's out there today, there's going to be impact at the consumer level as well. So I think it's important to think about where does the consumer play in all of this, and everybody in this room is a consumer. We all have that power to play a role in that shift, right? And in demanding where we want our brands and our fossil fuel companies everybody else, where they do want to go. So I don't know, Toby, if you work in the campaigning side, but is that what you guys try to push for as well? How much of a role do you think consumers play in all of this?
Yeah, I think I would say I think there are cases where that makes sense. So when we try to think about how to build more grassroots power, which is our starting point, I think there are certainly occasions and contexts of campaigns where organizing people as consumers is important. I think more often, at least in the work that I've done recently, the frame is more organizing people as not qua consumer, but as citizens, which can include people who aren't citizens of the U.S. We can have global citizenship or some notion like that. But I was been thinking about this question of government versus business, and I think there's we're all headed in the same direction, but there needs to be this division of labor between people playing very different roles, even as we're all going the same direction. So I do think there's in the end there has to be a role for the private sector to play in solutions. But in my work, given the demands that we organize around, we most often end up taking a much more adversarial position towards corporate power, and we want to push. Usually, we're targeting government decision makers to agree to our demands. But I think something that I like is when we can figure out a campaign strategy that combines actions that target corporations with actions that target decision makers in government. And one reason why that can be important is something that in my work we're always fighting against is the enormous power that corporations have over government, and that's time and time again, that's the major obstacle that we face. And so it can be helpful to have part of the strategy be, a direct action strategy that is targeting a corporation that's a particularly bad player, and then using that to polarize people around this issue through a lens of corporate power, so that in the end, part of what the appeal that we make to the decision maker in government is this is an issue of corporate power, and you need to be on the right side of like the public interest against corporate power. And so that's in my work how we understand the role of like what part of our campaign work is addressing government, which part of our campaign work is addressing the private sector.
Yeah, I think it's really interesting that Tessa had mentioned greenwashing and how companies tend to do that to kind of derail the sort of advocacy that the climate justice movement is doing. And one of the ways that they've sort of greenwashed is a lot of these funded studies. And I was curious to know how much weight these studies actually have in legal disputes. How seriously do courts take these studies that counter what scientists are saying about climate change and the climate crisis? I had this down for Tabitha and Vivian, but any of you are welcome to contribute to that.
I'm not sure what the answer is for the courts, but I would lean on our colleagues here who are in the legal field on that. But I think that anytime you put out a paper without an action plan, it's useless. So I do think that a lot of brands try to fund these studies and try to fund and have a corporate social responsibility strategy that is completely unattached to the work that they actually do. To the impact that they actually make in the world. And when that happens, it's definitely just a distraction in our minds than anything useful.
I don't have much to say. I don't trust anything that corporations say to police themselves. Zero. That's just my starting point.
Marika, Tessa, do you guys have any reflections or experience in that?
Well, and I think in the Dutch litigation, we saw that the courts really went down to the nitty-gritty of climate science and relied on IPCC reports mostly. And the submissions by the government, I think, were looked at, but the court really looked at climate science as an international consensus. And I think you're right, if we're seeing in the UK, but we're also saw in Germany that climate strategies really have to be founded on actual implementation plans. And if it's not enough, then you're just being sent back to the drawing boards by the courts. So that, I think, is a very, very good development.
I'm looking over my shoulder at Tessa as a cue, but I realize you can't see that. So Tessa, any reflections?
Yeah, I think just to add briefly to that, a real advantage of taking governments to court over corporations is that thanks to the UN FCCC, the climate summits that happen every year, and the Intergovernmental Panel on Climate Change reports that periodically accompany those summits. Those reports are, at least in part, the sort of executive summary of those reports is actually adopted by all national governments that are a party to the Climate Change Convention. So it is effectively impossible for governments to deny climate science that they have endorsed at the national level and at the international level through the adoption of IPCC science. So I think that is, one huge advantage of litigating against governments when it comes to at least starting with some sort of baseline consensus around the climate science, compared to going up against corporations who, as I say, have often very publicly challenged the basis for climate change science.
And that is something that I learned for the first time today. That is really, really interesting, and I suppose has kind of answered the question for me about who is better to sue. I want to speak a little bit about SLAPP suits. I know that they're very common here in the US, but there have been examples that, like through engaging with a lot of you, that have popped up all over Europe. And I think a lot of the challenges in South Africa kind of mimic that idea of exhausting funding of advocacy organizations. And I wanted to get a sense and a feel on some of basically the impact of SLAPP suits and also some of the action that might be coming up to prevent that from happening anymore. Again, I open it to anybody who has a little bit of experience. Tabitha, perhaps
I can come back to me, actually.
I can come back to you. Tessa, perhaps you have a little bit of insight.
Well, I think actually in Europe, a number of governments have taken steps to legislate against SLAPP suits. So they tend to be used less overtly as a tool for repressing activism that is trying to hold companies accountable for their actions. I do think, though, that companies and increasingly with the complicity of states use all sorts of other tools to surveil and intimidate activists. And of course, I mean, that is in no way comparable to the way in which environmental activists and defenders and human rights defenders are intimidated and assassinated, and in so many different ways have their human rights violated in the global south. But I think, in Europe at least, SLAPP suits have been marginalised through a lot of effort to get governments to make it quite difficult to bring lawsuits that have that as a basis.
I just realized that we went a little bit into the question and answer time, but I also don't see any questions. Oh, okay, there are questions. But I don't think that I am connected to the Wi-Fi. Let me grab those.
Okay.
Thank you. Okay, we've got questions. And I think I'll use the last 5 minutes of this session to address them. So one of the questions is it possible to bring criminal charges against individuals who are responsible? If only states are liable, many do not feel responsible. We need a signal that everybody can be held personally liable. So can we use something similar to the Nuremberg trials? Can Article 7 of the ECHR be used? That's a lot of legal speak. You guys understand the question? Okay. Since you understand, could you please answer it?
That's a great idea. I would love to see that become possible in the United States. The problem is that I don't think it is. I don't know about the legal mechanisms, but politically, it's not politically possible. Like, I would love to see that kind of personal accountability. I think my question is, like, how do we get to a point where it becomes realistic to think of that as a tool? And I think a lot of social and political change has to happen before that can be thought of realistically within the US context.
Anybody else have thoughts on this?
Well, I'm aware of this notion of ecocide, and I think that there was a movement, and I'm not sure what the actual status is, but under the International Criminal Court, that maybe the person that was in charge of the Brazilian of Brazil could qualify to that. I can't speak to that further, but the notion of ecocide, I think, is gaining a little bit of momentum, but I echo what you're saying. I'm not sure whether that will actually be a realistic route. The personal accountability part is not uncommon. For example, in the UK, a letter was written to the directors of Shell. So I think that we may be moving in that direction, but it has not, to my knowledge at least, become concrete.
Another question. I have this, and I direct this at Saru and Vivian just because of the countries that you operate in, is that somebody would like to know, how do we address land use issues associated with solar power, especially with smaller island nations?
Smaller what?
Island.
Can you repeat the question again?
Oh, how do we address land use issues associated with solar power, especially with smaller island nations?
Well, for my community, we've not dealt with the issue of solar energy and its land use. So at the moment, we don't have any precedent around that. But the other question she asked about personal this thing in the court. I think that within the context of business and human rights, we are also seeing emergence of people on their own, also seeking justice or personal liability against companies. I think we've said a couple of cases in Ogoni. And of course, within the context of the question of liability with the treaty process, I think that's one thing we're advocating under the treaty process. That's beyond communities, individuals can also take complaint. Now, the issue is how do we advance that forward, looking at some of the environment that we come from, particularly coming from Nigeria, which, as I said earlier, the weak legal systems that we have. And that brings me to that question you asked before about government versus businesses. I think for me, it's also location specific. Countries with weak legal systems, for me, based on my experience, getting judicial victories with the companies, strengthening whatever thing you are doing at national level. The Ogoni case in London, in the Border case, when the Border community won that case in London, it has a different impact at the level of the country because it now forces some of the judges to start taking some of the judicial activism that we see. So, I mean, something we never imagined before in Nigeria happened just last year, where one of the communities, up to the level of the Federal High Court and Supreme Court, got a judgment. In fact, committing share to pay the community money running into billions of naira. We couldn't have seen that before. But it's possible. If we were waiting on the government to make such legislation, it wouldn't work. But it would work because the Border community had won against Shell in London. So it now empowered the judges at the national level now to take such decisions. So that for me, it's a balance between it. Yeah, the state had to protect, but at the same time, looking at what we see in the country that we come from, particularly in the third world, where corporate power is still very strong. So for me, it has to be a balance between the two. Now, what I'm seeing happening in Nigeria today is that some of those victories is not informing the legislative processes that we are seeing. I was involved in the shadow report in 2005, and that when about using the UN system, and we raised questions about the Petroleum Industry Act. Which I mentioned before that most of these things were drawn in the early days of the oil industry, by the government, the oil company influencing such policy. But as they said, I think we got a recommendation from SED, requesting the Nigerian government to review the entire Petroleum Industry Act. Now, it took us long years of serious advocacy and engagement and all that. And the government started a process of reviewing that. It took us another about 5 to 6 years. And then last year, we got the Petroleum Industry Act passed, which is different from what was there in 1969. So I think it's an envelope of, as I said earlier, trying to use different mechanisms in trying to get this. I think for me, it also go down to the question of human rights and climate change that we're all involved with. If we start seeing progressive decisions coming from the entire human rights system within the UN, and then combine what is going on at the local level with the litigation process that's going on, I think for me, we will go a long way in dealing with this question. Sometimes the government, because of the sort of arrangement, particularly this period of trade and investment, and that is where we are having another big challenge now. Post-COVID, we are seeing, because COVID led to serious economic downturn of most of our countries, we are seeing a situation where even, the Tanzania case, where, of course, luxury tourism was being promoted, all because you want to boost the economy of the country and all that. And then you are seeing most of the trade oil permits going on in Africa now from Uganda to being including South Africa and the rest of them. So it means that we need to do more in terms of exploring all these mechanisms. I mean, it must be a combination of what the government can. I think I see something progress from South Africa recently around the coal-powered flare that both the judge and the community had to run requests for a risk assessment, risk assessment around climate change. I mean, we've never had that before. I mean, when they're demanding for EIA, and then they said the climate risk need to be included in the EIA. That wasn't part of what we were seeing before. But now climate risk is now being demanded, and South Africa has demanded that, which means that can also go and open another floodgate of potential demand across the continent, particularly now that because of improving economic growth, most of our countries in Africa are now shifting towards running after oil extraction and gas exploitation.
Unfortunately, we are out of time, but I will conclude with something that you said, Saru, is that we have to employ various strategies if we're going to address the climate crisis. And it's like what I said earlier about how we all have a role to play. And I want to invite or thank you all, but also invite you to have a final word of hope as we close the session. And we'll start with you, Tessa, because you're online.
Thank you, Angelo. So I guess really my final word of hope is picking up on what you just said, which is that it's important for people to understand, you know, in the context of this session more broadly, that it's not just lawyers that matter in the fight against the climate crisis. You know, everyone can contribute to holding those two sets of actors, you know, governments and the fossil fuel industry, accountable. And I'm surrounded in the work that I do by people who contribute a huge range of skills to that fight. So there is something for all of us to do. And, you know, I think it's often said that what creates hope is action. You know, action begets hope, begets action, begets hope. So the sooner you can get involved, I think the more determined, driven, and ultimately hopeful you feel.
Vita, how about you?
I find hope in the fact that I think the global system that we've been living under for decades is becoming increasingly unstable, and there's more and more openness to question the rules, and there's a real risk that can move in like a more dangerous direction, but there's also real openings for progress. And I'll go back to one thing I named before, which is the show of unity that we have seen from blocks of global south countries is really critical and creates real openings to shift the policies of global north countries that have stood in the way of justice. So bringing demands, just clear demands of justice to global north countries, and also on some occasions that will have to be directed to China as well, is a way that I think we can see some hope for the future of the global system.
Marika?
Thank you. And thank you for this very wonderful discussion, first of all. I am hopeful because I see that litigation really has an impact on how the private sector acts, on how government acts, and even though we'll keep on having opinions and accountability remains important, but there is momentum, and I feel it in society. I feel it in the younger generation, the Gen Z coming up. They're so passionate, and everyone wants to move in the same direction, and as long as we keep up that momentum, I think we'll get there. So there's a lot to be hopeful about, as well as, let's also the sun is there.
Yes, and thanks for having me as well. Great discussion. Thanks for moderating. I think I find hope in the number of tools, the expansion of tools and resources and strategies that we have in addressing climate change today. Even just with the 4,000 people who have signed up to be a part of this conference, it's incredible. It's an incredible force of hope and power. And then also that the inclusion of human rights into this discussion, more and more of that is happening, and more of that is resulting in people whose voice were not accounted for in the past, or who are not even recognized as those who have been impacted by climate change, is now at the forefront of these conversations, and that brings me great hope.
The best
Yeah,
for life.
even for me, well, I thank you for moderation and thank you, my fellow panelists here. I believe in the South African principle and philosophy of Ubuntu, that you are because we are. And I believe that the strength that, as I said earlier, that there is innate power in all of us. And if we can combine that power, I mean, coming from my indigenous community that I come from, if we bring that power to bear, I don't see, no matter how these guys appear powerful, if we bring that power together as a collective, I think we can move beyond where we are. And that's, for me, that is the hope. I see that power rising, I see that collectivity, I see young people coming up in all dimensions. I was a young boy when I started in secondary school, but I see a growing range of young men and women putting their hands on the line at this point, which gives a whole lot of hope. Across different indigenous communities, people are rising up, which for me gives me a lot of hope. Young men are rising up. The discussion about just transition and intersectionality is all there. So I see hope. I'm also hopeful looking back at my community. We are the very first to have shot shell out of our land for up to 20 years now. So in terms of climate change and the gas trade, I can say for 20 years now we've been saved from some of those oil GHG emissions, and that came not because we went to court, it came because of people's power. When we march on the streets, march on the gas location and oil locations, and say I had no alternative than a pack out of Ogoni land. That is people's power, and that for me is the hope that I see for tomorrow. I started in my opening statement that the difference between the future and the past lies in what we are doing here now, and that I thank all of you.
Oh man, thank you so much. Thank you to all of you that attended and that are streaming online. And thank you to the University of Boulder for hosting us.